If a police officer activates their lights to pull you over and you decide to flee to your home, drive into your garage, and wait there, and if the cop comes inside, try to argue that they don't have a warrant and cannot arrest you, are you in the right? Well, this issue was just covered in a Rhode Island Traffic Tribunal appeals decision from August of this year. This case involves a police officer in the Charlestown Police Department pulling over a driver who fit the description of a bolo or be on the lookout of a black BMW driving erratically. The officer found the black BMW and decides to initiate a traffic stop after observing the BMW driving erratically, changing lanes, crossing over the double yellow lines, correcting itself, and then going back over the double yellow line. So there were some facts that supported that the driver was in fact driving erratically or under the influence. The officer tried to initiate the traffic stop. However, the driver continued to drive into their home, into their garage, and sat there. The officer then got out of their cruiser, parked on the street, walked up the garage without a warrant into the driver's garage, and observed clear signs of intoxication, such as bloodshot eyes and other things of that nature. So the officer thereupon placed the driver under arrest for driving under the influence and asked the driver to submit to a chemical test or a breathalyzer test. The driver goes to the traffic tribunal, and their attorney, a very good attorney, argues that the search and the seizure of the driver was unconstitutional because it didn't fall within the Fourth Amendment, protection against unreasonable searches and seizures. And they would normally be right, but the traffic tribunal did an inquiry into the Fourth Amendment and determined that while you do need a warrant to enter into someone's home, the Fourth Amendment is very clear on that issue. It makes it clear that you cannot enter into someone's home without reasonable suspicion that they're committing a crime or a warrant. There is an exception to the Fourth Amendment rule to getting a warrant, which is known as exigent circumstances, and more particularly one known as the hot pursuit doctrine. And the hot pursuit doctrine basically allows police, if they are in hot pursuit of a motorist, that they can, in fact, continue that pursuit and apprehend the suspect. Now, there are questions as to when a hot pursuit ends. If cops are following somebody and they lose the person and then 5 minutes later find a car that kind of looks like the same car, that hot pursuit has ended. They almost have to maintain a visual contact. It is a case-by-case, fact-by-fact situation. But if the officers do not lose sight of the car, the Constitution does not reward people for simply trying to flee police and then driving fast enough to lose them and then argue that the police need to go and see a judge to get a warrant to, in this case, determine if the driver was operating under the influence of alcohol. So the tribunal, in this case, the appeals court, found that the exigent circumstance of hot pursuit existed. So the answer to the question is no. If you are driving a car in Rhode Island and the police come behind you and activate their lights and your plan is to flee and try to drive into your garage, close the garage and argue that the police cannot arrest you because they need a warrant, it's not going to work according to the traffic tribunal. Now, this case is appealable. They can appeal it really all the way up to the Supreme Court of the United States. But from the traffic tribunal portion, they have to appeal it up to the district court and then the Supreme Court of Rhode Island. So I don't see that happening. I will follow this case. So thank you for watching the video. Hope you enjoyed. Please feel free to like, share, subscribe with your friends. If you want to see more videos on constitutional law, DUIs, let me know. I will do my best to find good cases that clearly explain the issues. Until next time, be safe, be well, and take care.